Hello viewers, in this lesson we will learn about the relationship between banker and customer part 2, objectives. To learn about the meaning and definition of customer and customers' accounts. To learn about the special types of customers. To learn about the rights of customers under the Consumer Protection Act 1986. To learn about the banking ombudsman. Viewers, now we will examine the meaning and definition of customer and customers' accounts. Meaning and definition. Lesson 1 contains a detailed analysis of the term and also the concept of banking. In general connotation, a person who carries the business of banking is called as a banker. There is no definition of a customer under the statute. In general connotation, a customer is one who avails the services of a banker by operating an account. Basically, the nature of relationship between a banker and the customer is contractual. This aspect was well analyzed in the English court judgment in George Simpson versus Swiss Bank Corporation. Under the Indian law, the term customer was well analyzed by the Kerala High Court in Central Bank of India Limited versus Gopinathan Nair. The Kerala High Court held that the word customer is not defined in the Negotiable Instruments Act, but broadly speaking, a customer is a person who has the habit of resorting to the same place or person to do the business. So far as banking transactions are concerned, he is a person whose money has been accepted on the footing that the banker will honor up to the amount standing to his credit, irrespective of his connection, being of short or long standing. Even though the definition of customer can be drawn from the English statutes and others, in the Indian context, the authenticity of the definition is found in the KYC policy, that is, Know Your Customer policy in India, as notified by the Reserve Bank of India, which is as follows. A customer is a person or entity that maintains an account and or has a business relationship with the bank. One on whose behalf the account is maintained, that is, the beneficial owner. Reference, Government of India notification dated February 12, 2010, Rule 9, Sub-Rule 1A of PMLA rules. Beneficial owner means the natural person who ultimately owns or controls a client and or the person on whose behalf a transaction is being conducted, and includes a person who exercises ultimate effective control over a juridical person. Beneficiaries of transactions conducted by professional intermediaries such as stockbrokers, chartered accountants, solicitors, etc., as permitted under the law, and any person or entity connected with a financial transaction which can pose significant reputational or other risks to the bank, say a wire transfer or issue of a high value demand draft as a single transaction. Further, under the explanation to Section 45Z of the Banking Regulation Act 1949, the term customer includes a government department and also a corporation incorporated by or under any law. It is pertinent to note that a customer must fulfill the requirements of the banks as well as KYC norms to join as a customer. The minors and other institutions like the companies, firms, trusts and like ones must have proper authority to open an account. Sometimes a bank itself can be a customer of another, as for example, if a bank has a drawing account with another bank and it is not a member of the clearing house, engaging the other bank to clear its checks. The non-clearing bank is in every sense of the word the customer of the clearing bank. Viewers, we will now learn about the special types of customers. In the banking practice, the bankers must take special care about certain types of customers who are called as special types of customers of the bankers. They are narrated here. Minors. Even though a minor, that is a person who has not completed 18 years of age, is incompetent to enter into a contract under the Indian Contract Act 1872, the banker can permit a minor to open an account as per the norms of the bank. Sometimes, under an order issued by a court of law, the banker may have to open an account for a minor. Due to the stringent law in protection of a minor, the banker must be extremely careful in dealing with a minor. As per the prudent banking practice, the banker can open an account in the name of a minor, but to be operated by the natural guardian or the guardian appointed by the court or a testamentary guardian. Further, if the minor is above the age of 12 years, now the present banking practice permits the minor to operate the accounts by himself, but only savings bank account is permitted to be operated. Two minors can open a joint account also, but the ultimate responsibility falls on the guardian. Here, guardian implies a father and on his demise the mother. However, the Supreme Court in Gita Hariharan and another verses, RBI and another, held that the mother can also act as a natural guardian of a Hindu minor even during the lifetime of the father under certain extraordinary circumstances. A minor may draw, endorse or negotiate a check or a bill of exchange, but he cannot be held liable on such check or bill of exchange. Regarding the liability of a minor, the provisions of the Indian Contract Act apply, especially the provisions under section 65 relating to the supply of necessaries to a minor. Illiterates. Illiterate customers cannot sign. The bankers take their thumb impression. Proper care has to be taken regarding their identity and on permitting them to withdraw the funds. Trust. A trust is created to safeguard the interest of the beneficiary. The banker must examine the trust deed in order to allow the operation of bank accounts of the trust, as the trust deed, which is the base of the trust, speaks about the persons competent to operate the bank accounts of the trust. Attorneys. A customer can operate a bank account through his power of attorney holder. The power of attorney is governed under the Indian Contract Act 1872 and also the Powers of Attorney Act 1882. The formalities on the granting of power must be complied with in accordance with the above legislations and also the Indian Stamp Act 1899. Partnership firms. A partnership firm can open an account with a banker. It shall be in accordance with partnership deed and the banker will act as per this deed and also the letter or mandate submitted by all the partners of the firm. The partnership firm is governed under the provisions of the Indian Partnership Act 1932 and also the Indian Contract Act 1872. Companies. The companies, also termed as joint stack companies, are governed by the Companies Act 2013 and the previous company legislations. Further, the companies are regulated by their own memorandum and articles of association. The bankers must allow the operations by a company only in accordance with the provisions of the memorandum and articles of association. Further, a board resolution is also required to open an account by a company in a bank. The operational and borrowing powers of the directors of the company are stipulated in the Articles of Association of the company. The banker must ensure that in the company transactions, it does not commit any ultra-vires act, that is, an act against the objective clause of the Memorandum of Association or an act beyond the powers granted by the Articles of Association. Joint Hindu family. A joint Hindu family is one which possesses properties from the ancestors and also carries on ancestral business. A joint Hindu family is governed by the Hindu law. The family business and the assets are managed by the eldest male member called as the Karta or manager, who has an implied authority to run the bank accounts, take loans and execute the necessary documents in this regard. He can also pledge the securities for the purpose of family business. The Karta can open and operate a bank account for the purpose of the family business after submitting the necessary documents and fulfilling the KYC norms. In case of disputes among the co-partners, the bank accounts must be operated either by the original Karta or as per the orders of any court of law. Charitable institutions, clubs and societies. These institutions can maintain bank accounts. The banks must verify the bylaws of these bodies and also the resolution of the managing committee authorizing the concerned persons to operate the bank accounts. The borrowing powers of these institutions are embedded in the bylaws or the charter or the memorandum. Executors and administrators. These persons are appointed either through a will or by a court of law to conduct the affairs of a person after his death. They can realize the assets and pay off the debts of the deceased person. They can operate bank accounts and their activities are regulated as per the will or the letter of administration issued by a court. Joint accounts. Two or more persons can jointly operate bank accounts. The joint account may be operated either by all the depositors jointly or either or survivor of them or by the former or survivor of them. All this depends upon the mandate given by the customers. The legal effect of joint account holder and the devolution of joint rights in case of death of any of the joint holders are enumerated under section 45 of the Indian Contract Act 1872. Lunatics. Under section 11, read with sections 10 and 12 of the Indian Contract Act 1872, a person of unsound mind cannot enter into a contract and so he cannot operate any bank account. If a court of law appoints any administrator of the properties of a lunatic or other persons who are of unsound mind, the administrator can operate a bank account. In case a banker receives any authenticated information that an account holder has become a lunatic, it should immediately suspend all banking operations until it is proved that the account holder is sane, or in the event of any intervention of a court of law, the banker must follow the court's orders. Husband and wife. A husband and wife are independent persons for the purpose of operating bank accounts in their individual names. They are not liable for each other's debts unless they stand as guarantors for each other. Today, a woman is a femi-soul. Parda-nashin woman. Primarily, a Parda-nashin woman's identity cannot be found as her face is not shown to the banker. These persons maintain a total seclusion as per their own customs and religion. The bankers may stipulate their own rules permitting a Parda-nashin woman to operate a bank account. Viewers, now we will learn about the rights of customers under the Consumer Protection Act 1986. The Consumer Protection Act 1986 provides several rights to the consumer of goods and services. Under Clause O to subsection 1 of Section 2 of the Consumer Protection Act, services include banking services also. Thus, a customer is a consumer. Subclause 2 to Clause D2 subsection 1 of Section 2 of the Consumer Protection Act authenticates this point. The customer of a banker can charge the banker for deficiency of service in the event the bank's acts and omissions result in causing any damage to him in a consumer forum. Under Clause G2 subsection 1 of Section 2 of the Consumer Protection Act, deficiency means any fault, imperfection, shortcoming or inadequacy in the quality, nature and manner of performance which is required to be maintained by or under any law for the time being in force or has been undertaken to be performed by a person in pursuance of a contract or otherwise in relation to any service. The deficiency of service claimed against a banker may relate to several issues. Based on the various decisions of consumer fora like the state commissions, National Commission and the Supreme Court, the different issues which are the subjects of disputes under the Consumer Protection Act relating to bankers are narrated hereunder. Wrongful dishonor of checks, negligence in payment and collection of checks, delay, failure in repaying deposits, wrongful refusal to grant loans, charging high rates of interest, non-return of documents after repayment of the whole loan, wrongful exercise of the right of lien, wrongful dishonor of bank guarantees, loss of articles kept in lockers, lack of security in bank's premises, wrongful stoppage of operation of bank accounts, wrongful closure of the customer's accounts without instructions, charging exorbitantly service charges, violation of RBI, government instructions, guidelines, orders, vicarious liability for the acts and omissions of the bank staff, rude behavior of the banker's staff, auction of pledged articles without notice or improper notice. The customers may approach the district forum, the state commission, the national commission, and finally the Supreme Court for the resolution of their disputes as provided under the Consumer Protection Act. Viewers, now we will learn about the banking ombudsman. To provide an expeditious and also inexpensive forum to bank customers for resolution of complaints relating to the banking services, the Banking Ombudsman scheme was first introduced by the Reserve Bank of India under Section 35A of the Banking Regulation Act 1949 in the year 1995. It was revised in the year 2002 and further revised in the year 2006. The scope was widened further in the year 2009. Presently, the scheme covers various subjects of banking operations, including the subjects such as credit card compliance, deficiencies in providing promised services, deficiencies arising out of internet banking. The scheme is fully staffed and funded by the Reserve Bank of India. Complaints can be filed in any form, including online. The customers can also appeal to the Reserve Bank of India against the awards given by the Banking Ombudsman. Brief details of the scheme. The Banking Ombudsman is a senior official appointed by the Reserve Bank of India. As on now, About 15 banking ombudsmen are appointed with their offices mostly located in the state capitals. Under the Banking Ombudsman Scheme 2006, all scheduled commercial banks, regional rural banks and scheduled primary cooperative banks are covered. Mostly, all the issues pertaining to deficiency in banking service can be the grounds of any complaint before the Ombudsman. A customer, before approaching the Ombudsman, must approach the bank first and convey its grievance. And if he does not get any reply or the reply is not satisfactory, then he can approach the Ombudsman. The Ombudsman, on receipt of the complaint from a customer, will issue notice to the bank and try to settle the issue amicably, and failing which he can pass an appropriate award after giving an equal opportunity of being heard to both the parties. He can reject the complaint if it is frivolous or the compensation sought is beyond rupees 10 lakhs or requires consideration of a very elaborate evidence. He can also reject if he finds that the complaint is without any sufficient cause or that it is not pursued by the complainant with reasonable diligence, or that in his opinion there is no loss or damage or inconvenience caused to the complainant. The award of the Ombudsman can be appealed to the appellate authority within 30 days of the receipt of the award. The appellate authority may condone any delay in filing the appeal on a proper reason by another 30 days period. The appellate authority may dismiss the appeal or allow it by setting aside the award or send the matter to the Ombudsman for fresh disposal in accordance with such directions as the appellate authority may consider necessary or proper, or modify the award and pass such directions as may be necessary to give effect to the modified award or pass any other order as it may deem fit. Against the order of the appellate authority, the aggrieved has no further remedy under the scheme, but he can approach the High Court under Article 226 or the Supreme Court under Article 32 of the Constitution of India, as the case may be. The students are advised to go through the Ombudsman scheme thoroughly, which is available in the RBI website. Viewers, we will learn more on banking law in the following lessons. I hope you have enjoyed this session. Thank you very much.